Let me make a brief announcement while you're being seated. Many people have asked about the availability of the tapes for the various programs, and if you're interested in obtaining the tapes for the programs, you should contact Suzette Martinez, who's the Director of Defense Counsel, at our office for Defense Counsel. The number is 543-1020, or you can contact her personally here at the seminar, and she can help you put things together to have any tapes that you'd be interested in purchasing. The subject of the seminar that we have before us today is the Coomis case, and certainly, in my opinion, nothing has more profoundly affected our practice on a day-to-day basis than the Coomis case. We can have changes in products liability cases, changes in bad faith on the law, but in terms of how we really practice, who handles the cases, where the carriers send the cases, and how the cases are handled with other counsel, the Coomis cases had a profound effect on this. Now, we have a wonderful panel before us today of some very distinguished attorneys. I have it on good authority that they made the mistake of preparing for this lecture at the Olympic Club. And this is a true story. The only place that they had available for them to meet was the ladies' lounge. So I'm looking forward to what's come out of that. From what I understand, these fellows have, for the main part, just argued about the issues involving Coomis. For instance, it's reported that Bob Dryden said of some of the people that he was with, usually Ed McFetridge, that Ed thought the shortest distance between 2 points was a tunnel. And Ed said of Dryden, as I remember, he said that some people don't know what's happening, but Dryden doesn't even suspect.
It's a lie.
Of course, Lucas said of McFetridge that he should have been preparing for the lecture last night, but instead of that, he was making a video documentary of the evolution of the hood ornament, which gives you some idea of what a great guy he is. And Shibley was accused of saying during the meeting that he had discovered that if you put ice in a warm glass, it's harder to find. So we have a lot to look forward to. But on the serious side, I could go into all of the accolades that these gentlemen are entitled to, but suffice it to say that we have to my immediate left Robert Dryden, who is a premier trial attorney and a member of the American College of Trial Lawyers. The same exact fact goes for Mr. Lucas, who's next to him, and Ed McFetridge, if you can believe that. And then to top it off, we have a member from industry, Robert Shibley, on the far left, who just happens to have graduated from law school in Minnesota cum laude and is a member of the American Bar Association and the Minnesota Bar Association. They're here to tell us what's happened with Coomis, how it's evolved, and hopefully some interesting insight into what SB 241 has done to Coomis practice. Gentlemen?
Thank you, both.
Very well.
We are gathered together today because of an event that occurred on December 3rd.
Okay.
No? Now? Am I getting louder? Okay? Can everybody hear me? Okay.
If they can hear you, we're in trouble.
As I was saying, we are here because of an event that occurred on December 3rd, 1984. Remember that date, a date that will remain in infamy when a court in San Diego made a dastardly attack against defense counsel throughout the state of California by accusing them of having a conflict of interest anytime a reservation of rights letter was written by an insurance company. We are also here because of a recent piece of legislation, SB 241, which is Civil Code 2860, that has now been enacted and will become in force in January of 1988. which significantly affects all handling of Cumas cases. I should mention, however, that this panel believes that if the original Cumas decision put our children through school, this legislation is going to put our grandchildren through college. There are many more problems created by this legislation than it solves, and it's going to be something that we're going to be living with and litigating for some period of time. For this reason, we're going to take you through a little bit of the history of Cumas, how it arrived. We're going to tell you what the present state of the law is and give you our thoughts as to where it might be going. We don't agree on all issues. We don't agree on all of the solutions. But I think that the material that we have for you should prove very interesting. Let's go through a little bit and briefly discuss how Cumas came about. I think you lawyers in this group are familiar with the decision in executive aviation. That was the grandfather, the godfather of the Cumas decision. It was a case in which an attorney had an unbelievable conflict because he was representing an insured in a case where in the underlying action, that issue would determine the liability of the insured, and in a declaratory relief action, that issue would determine whether there was coverage, and that carrier had the brilliant foresight to hire the same lawyer to handle both cases. And quite understandably, when the insured objected to this and hired their own lawyer to represent the insured in the underlying action, they sought their attorney's fees and they recovered them. I can remember reading that case at the time it came out in 1971 and saying, does this really mean what it says? And everyone I talked to about it with said, don't mention that case, don't ever bring it up again. Just keep your mouth shut. If this gets out, we're in deep trouble. And it was buried. It was buried until the Ninth Circuit picked up the theory in the previews case. And that was the first time that any court in California found that the existence of a reservation of rights letter with intentional and willful conduct seeking punitive damages was sufficient to raise the conflict requiring the carrier to pay the attorney's fees of the independent counsel for the insured. We will be referring to the Cumas Counsel, and I should say Mr. Shively has done great research on this, and the correct pronunciation is Cumas, not Cumas. So when we say Cumas, that is the correct pronunciation. In any event, we will also be referring to the attorney appointed by the carrier as retained counsel, so that you understand our language. In any event, the previous case was a very simple case in 1981 that simply held that they had to pay the attorney's fees of the independent counsel. This was followed by a decision in the federal district court by Judge Zerpeli, Nike versus Atlantic, and this is all of these cases are cited in the bibliography, so you only have to look there for the citations if you want them. That followed the previous case very simply, but it added one factor, and that is the element of control, that where there is this conflict created by a reservation of rights, the insured cannot give up control of the litigation, or the carrier can't take control of the litigation. It must be taken over by the insured if the insured wants to maintain control. And then finally, we have the Cumas case itself, which you are all familiar with. Basically, it simply held that the defense lawyer was a total, complete rat that was going to make sure that the insured ended up with no coverage. My friend Dick Lucas does not agree with that totally, but that was the way we viewed it at the time, and that occurred in December of 1984 and was the subject of a panel here at that time. We have now come full circle, and following the Cumis case, when the attorney's fees and costs were skyrocketing, we got a breath of fresh air from the decision in the McKee case. The McKee case was written by a companion court to the Cumis court and was written by Justice Kaufman, who is now on the California Supreme Court. Justice Kaufman did everything he could to limit the scope of the Cumis decision. He did this, actually, all of what he says is dicta because the plaintiff did not have the standing to challenge the attorney. It came up by way of a petition to remove the defense lawyer by the plaintiff. And the court held it did not have standing, but it went on to decide that Cumis did not apply in every case where there was a reservation of rights. And where there was an issue that did not depend upon the attorney representing the insured as far as the evidence in the case is concerned, the reservation of rights would not create a conflict requiring a second attorney and the carrier to pay his fees. The issue in that case involved, the coverage issue involved the question of whether the driver of the vehicle was a resident of the insured's household, which would make him an insured and bar the lawsuit, which would eliminate coverage. Justice Kaufman said you can litigate that without regard to the negligence of the driver, and therefore there was no conflict. This is very important, and all of these cases are still important because the enactment of 2860 embodies the language of the McKee case, and the question of conflict becomes very important to be decided on a case-by-case basis. Well, before we get into the act itself, I'd like to ask Bob Shively to give us a few remarks from the industry standpoint on what the problems have been with Cumis and what he has faced as a representative of that great insurance company, Royal Globe Insurance Company.
We changed the name. It's no longer Royal Globe. It's just Royal Insurance Company.
Oh, that's right.
Very important.
The stigma is there.
They had a royalty sandwich at the Olympic Club, too. I didn't have it. I was wondering what the letters in Cumis stood for, and this morning while I was shaving, I was telling the guys that I figured out what Cumis, the letters stand for, and that's court unilaterally making insurers suffer. And I also determined that, in my mind, a Cumis attorney, present company accepted, Dick, means come unto me, insurer's surplus. We don't have enough of that left. Well, first of all, the effects of the Cumis decision itself. First of all, total costs and attorney's fees in particular on a Cumis file increased substantially over what carriers pay their retained counsel. And what carriers pay their insurance counsel, I'm sure at least 50% of those in the room will agree that they're very fair and generous hourly rate.
That's right.
And Ed agreed this morning that was true.
We'd go that route anytime.
And not only is the hourly rate higher than usually paid to retain counsel, but many times the bills from Cumis counsel give evidence of excessive hours put in, more than the normally retained attorney would put in on that type of a case. Additionally, billings are often in a lump sum manner with no time breakouts for each activity and what attorney in the firm did it. it's very hard to challenge these total lump sum billings. Expensive experts are used, and with no consultation with the carrier on the choice of the expert. And sometimes every last bit of possible legal discovery is done. For example, taking deposition of the 15 witnesses when 2, 3, or 4, maybe at the most, were necessary. And also they resist alternative dispute resolution, arbitration and mediation, which you're hearing a lot about today. Another matter raised by the CUMIS and also by Senate Bill 241 is this matter of control. Who has the right of control of the lawsuit? The CUMIS decision held that where there is a conflict, the insurer may not compel the insured to surrender control of the litigation. I'm not sure what the court meant by surrendering control. I've always acted under the assumption that the carrier does not have the right to control the nature or the extent of the defense if it conflicts with what the trial attorney determines is in the best interests of the insured. And I would think that holds true whether it be a retained counsel or an independent counsel. And the only time I would challenge that if either counsel went so far out on a limb and did things that were completely unnecessary, that it increased the extent of the cost of the case. Some independent counsel, however, took this matter of control to mean that, one, they did not have to listen to any suggestions made by the carrier as to the nature and extent of the defense to be provided. 2, attorney did not have to report to the carrier except to forward demands of the plaintiff. And 3, that the attorney could merely tell the claims person to show up at the mandatory settlement conference with checkbook in hand. Oftentimes under CUMIS, the carrier is not given necessary information, and yet the independent counsel is demanding that the carrier pay the settlement amount under threat of bad faith. And the threat of bad faith is a serious matter. We get up and turn wrong when we leave our desks at the claim desks, and we're in bad faith, it seems. Of course, the carrier had and still has, even under this new bill, has the option of not sending a reservation of rights letter. But you have to remember this, that you're thus sacrificing the right to raise coverage issues later.
Thanks, Bob. Dick Lucas is our token CUMIS lawyer. But
I didn't have a black shirt or a black tie to wear, and I didn't have the whole black hat. And I went looking for him, and finally Ed said it's not necessary. When you open your mouth, people will get the picture.
He'll take care of it. Dick is actually a very experienced, heavy trial lawyer with the Orrick firm. He once started a trial in December, and the jury came in July, and then, or was given to the jury in July, and it was out for 2 weeks before it got hung.
Thanks, Ed.
They went on to have it determined by the court. But, Dick, what about the complex case? I mean, all of us in this room who are attorneys, all of the insurance claims representatives, handle many cases on a routine basis. But when you get into antitrust, blue sky laws, banking laws, you're getting into complex areas. Have you acted as CUMIS counsel in those areas? And if so, how do you handle it?
Well, yeah, I have acted as CUMIS counsel in those areas, and I handle it the same way we handle other things in the office, with the exception that we learn to report more regularly and more completely to our insurance people than we do ordinarily to our corporate clients for reasons that are not all that relevant or important to go into. But we learned early on that carriers want frequent reports, and we give them the reports, and And I don't know of anyone who questions their entitlement to such reports.
Do you feel that some of the areas that you are in are areas that, the standard defense counsel can handle? I mean, do you see guys like Dryden in antitrust cases?
Bob has told me, and I have to believe
He's out of
him.
the rear-ender business now, and I thought maybe...
I was out of control of those
He told me
people,
he'll
but I
take
have a
any
pig on
case.
ice, believe me.
Bob is fully qualified to take... Stop it, Bob. fully qualified to handle any case.
I have never let substantive law, procedural law bother anything that I attack, one way or the other.
I think of it in terms, Ed, really two things that give the Kumis idea legitimacy to me. One, there are specialties. Antitrust is a specialty. Securities law is a specialty. There are other specialties. And those specialties are not always found or practiced in all of the firms that the carriers traditionally engage. So there can be the idea that the case calls for a specialty that the retained counsel doesn't have. That can or cannot be true, but that is certainly a very real possibility. The other, and perhaps cleaner and even more legitimate reason for there being something like the Kumis case is oftentimes a corporate client develops, rightly or wrongly, a confidence in the lawyers they deal with on a day-by-day basis. And when they are sued in an area where there is also some coverage and maybe not complete coverage, they feel more comfortable with their regular counsel. And the Kumis case created more than an opportunity. It created something of a guideline. I think the guidelines are still emerging, but something of a guideline for that insured corporate client to tell the carrier under given circumstances that the corporate client wants its own counsel, the counsel that they've dealt with over the years, and they want the carrier to pay the counsel the same fees, always eminently reasonable, that the corporation was paying those corporate lawyers. So I think those are the two areas that we see.
Okay. Well, let's get into the new act. I know that's why most of you are here, which is Senate Bill 241, which is also Civil Code Section 2860. This act is a result of an emergency compromise by our friends from the CTLA because several conservative groups were trying to attack their contingency fee structure. And we've now figured out that any time we need legislation, we just go and attack the contingency fee structure, and the CTLA will just say, "What do you want?" And they sat down and scribbled out this and several other bills that have affected products liability, Mary Carter agreements, and other things that will produce litigation for many years to come. But let's go through it. The first premise of this act is that if there is a duty to defend and if there is a conflict, there may be a duty to provide independent counsel. Now, the biggest problem that we see in this act is actually twofold. First of all, it recognizes and approves the Kumis principle. Many of us thought that whenever legislation was going to come down in this area, it was going to eliminate Kumis, say, you're all wet. They didn't do that. And Dick will talk about the constitutional aspects of that in a few minutes, but what they simply said, okay, Kumis is here. We want to make it operate the way we want it to operate. And so what they did was set forth some rules and procedures for the operation of the Kumis principles. In doing so, the essence of the thing that creates the duty to pay independent counsel is a conflict between the insurer or the defense attorney and the insured. And the question is, what is the conflict? They have not defined it. They do not give you any real guidelines for what the conflict is. That is why we're going to be in litigation for many thankful years to come. But Bob, why don't you tell us about what the Act says about the conflict? What is definitely not a conflict?
When we were preparing for this seminar, if you can call it that nicely, and the last meeting we had at the Ladies' Lounge was related to me by Ed that he came over here a little early and he said that some of the attorneys, appellate attorneys and others, have said, well, we've seen the end of CUMUS now with Senate Bill 241, which adds Civil Code 2860 to the law. And the more that we got into this preparation for this subject, the more I found out, and I'm pretty sure the others did too, that by God, there was a heck of a lot more to this CUMUS than we initially thought. And those questions that arose out of a really working relationship in your daily practice with the industry and with CUMUS counsel with that decision, and the obligations, ethical and statutory, that are placed upon defense counsel, the more problems you have. As far as sending your grandchildren through school on the litigation that's going to come out of this Senate Bill 241, I don't think there's any doubt about that. We're just seeing the tip of the iceberg now with respect to the interpretation and the language of 241, which adopts a lot of the language, probably improperly so, out of CUMUS. If you'll recall, the McGee court criticized the CUMUS opinion, and they're both appellate court decisions on an equal level, criticized the appellate decision in CUMUS by saying it was overly broad, unnecessary language, and so forth, and they cut back on it by virtue of an area of a policy there that did not really have any effect upon the underlying case, which I think maybe it did. I think both decisions were rather poorly written. The situation that we have now is that the costs and the attorney's fees and the expenses of all types that are engendered by CUMUS counsel, many of whom do not have the stature or the ability to try a lawsuit like Dick Lucas, but many which just grab the CUMUS type situation to make fees. And that's all they do. They overwork the cases. We've all seen that. That is a direct result of no guidelines and no definitions set down by the CUMUS court. That has been carried over by the Senate Bill 241. There is no guideline here whatsoever with respect to many of the terms and many of the areas of this 241 as to when you don't need CUMUS counsel, when you should have CUMUS counsel, what the word solely means as far as punitive damages and excess limits are concerned. All of these things are going to be subject to interpretation and by lawsuits, irrespective of the agreement between certain members of a consortium and the CTLA that there's going to be a 5-year moratorium upon any cap on attorney's fees. We'll get into that with the constitutionality of this shortly. I think that what 241 has done is merely rearranged the deck chairs on the Titanic as far as the industry is concerned and as far as retained counsel are concerned. We've got one area here. It has, in some respects, help the industry by virtue of punitive damage allegations in a complaint, and by virtue of some cases which have held that if, in fact, there is no coverage, example where you have a contractual dispute among litigants and the policy does not provide coverage for defense or liability or indemnity coverage for contractual disputes. Now, there is a recent case, I'm sure that Paul Searle and others have discussed this with you this morning. It's the Halambros case, Halambros versus Insurance Company of the West. And that now has decided that where there is a coverage dispute, not a coverage dispute, but where there is a contractual dispute among the parties and the policy doesn't cover it, there simply is no basis for indemnity and there is no basis for a defense under the policy. Now, under the Senate bill, a carrier, when it gets a situation like that, under, say, another situation where it has a homeowner's policy and it's an automobile liability risk, where they say there is no coverage, we can now disclaim coverage and there isn't going to be any obligation to defend under 241. The only problem with it is that the legislation runs afoul of decided cases in the area that say that even where there is no coverage, you may have the obligation to defend. And also with respect to punitive damages. Now we're going to get into an area of discussion which has not been heated yet, but with respect to punitive damages. The Act says that no conflict of interest shall be deemed to exist as to allegations of punitive damages or be deemed to exist solely because an insured is sued for an amount in excess of the insurance policy limits. Well, what that did, by putting that language in this Act, this statute, was to overrule legislatively the Bogard case and the Merit versus Reserve life insurance case, which said that where there is a demand within the policy limits and the case is being defended by retained counsel, there is a prospect of a conflict of interest. Now, this Act says no, but the CTLA has already raised issues with respect to that language, irrespective of the 5-year moratorium where we're going to see liability, because in some cases where there is an allegation of punitive damages, you're going to have retained counsel in there, and retained counsel is going to have to be involved in discovery with respect to the other aspect of the Tort Liability Reform Act, the definition of malice, despicable conduct. And how is he going to develop the discovery with respect to despicable conduct under that new definition of malice without running afoul of the conflict of interest law? All these things are there, and they're very real, and they presently exist, and they're going to continue to exist. So this Senate bill has not put to rest problems you had under Cumas. I think it heightens them.
Well, Bob, let me ask you a question. This language which says there is no conflict simply because there's an allegation of punitive damages, I think that the reason that got in there was many carriers, in order to avoid Cumas counsel, have taken the position that they will not reserve their rights in punitive damage cases, but simply advise the insured that if punitive damages are awarded, they will not be covered and cannot be covered under California law. I think that this provision was inserted to permit that and give some legislative recognition, because what was happening was the Cumas attorney would say, you have a conflict. You don't know it, or you're not recognizing it, but you do, and I'm going to represent my client. The carrier would say, there's no conflict because we haven't reserved our rights. There are many cases going on right now where this issue is just dangling because the attorney is representing the insured. He's charging the carrier money. The carrier is not paying them. And I think that this was in part an effort to give some freedom to the carrier to do that. But it goes further. There are three ways that that the statute recognizes no conflict. There's no conflict just because the insured denies coverage. There's no conflict just because of punitive damages. And there's no conflict because there's a claim in excess of the limits. When is there a conflict? When there's a reservation of rights and the outcome can be controlled by retained counsel. What the hell does that mean, Bob?
Now that there isn't any clear definition under Cumas. There was never any clear definition under executive aviation or any of the other cases dealing with so-called conflict of interest. That had to be determined on a case-by-case basis. Attorneys had to look at the situation from all aspects and then be guided by the rules of professional conduct, ethical obligations in accepting the defense where there is a specter of a conflict of interest if you can conceivably take discovery, or if you could conceivably, which you wouldn't do under your ethical obligations in any event, but if you could, if the chance was there that the attorney could steer discovery, could steer the facts, could steer the case in preparation and at trial into an area there where there would be no coverage under the policy, intentional conduct, willful conduct, despicable conduct, whatever you want to call it, then a conflict arose. Now, this act says that there would be no conflict of interest in that situation. It is what they call discretionary language. It's permissive language rather than mandatory. It says a conflict may arise, if a conflict may arise. But that doesn't say that in every particular case where there is a conflict and there's no reservation of rights, that you have the obligation to go to the insured and tell him that there's a conflict and that he has a right to independent counsel paid for by the insurance carrier. It is only where there is a reservation of rights on an area of law where there could be steerage of the facts to show a conflict. Now, what are those? If you have certain areas of your policy there that would say, was the vehicle, assume an automobile liability case, the question is, was the vehicle insured under the policy? Was it on the declarations? You can defend that case because it is not such an issue that is subject to a factual control by the attorney, or is it a factual issue at the trial of the underlying case? It's an objective issue. Was the driver excluded or a resident relative? I have problems myself with the McGee case. Dick has problems with the McGee case, Dick Lucas, because I think that McGee was decided so narrowly that it really didn't set forth the applicable law. I think McGee was really Cumas in disguise. I think the plaintiff in the McGee case would be very interested in finding out if this man driving the car is going to get insurance coverage. And I think he'd be very interested in steering his case against that exclusion. And I think retained counsel there has an opportunity. He probably wouldn't do it, but he has the opportunity to steer that into that area also, to say, yeah, no coverage, he's resident relative or something like that. I think it was decided wrongly. I think that particular case needs a good look by everybody else. Suppose we have a case where there's contractual coverage or a contractual exclusion. Now, there's a case, let me give you this case, and it's a very good case on this issue. It is National Union versus Estate of Meyer, M-E-Y-E-R, 192, Calap 3rd, 866. Now, there was an aircraft policy involved in the case, and the question was whether the pilot held a current medical certificate. Plane went down. Lawsuit against by the heirs against the operator and so forth of the aircraft. Now, the court held that even though the lack of a medical certificate was not the cause of the crash, it didn't figure in, it's not important in the underlying case, still there is no coverage under the policy. And if no coverage under the policy, and you advise the insured under this act that there is no coverage, you don't have to provide Cumas counsel for that. That's an objective fact. No medical certificate. Nobody can steer the facts to say he did have a medical certificate. It's black and white. But it's the gray areas there where you have to consider, Bob Shibley will have to consider, as an in the insurance industry under the policy, you as retained counsel, if called in to take a look at the case and be employed to defend, are going to have to look at your ethical obligations and say, geez, I know I would never do this, but I think that this is some kind of an issue that I can control. And if I can control it, although I wouldn't, I am duty-bound to say I can't represent either one of you unless there's a consent. That's the way I look at it, Ed.
I think one problem that Bob just raised is you look at the conflict from the beginning rather than the end. There is that Native Son case, which is in the syllabus, where they looked at the conduct of the lawyer after the fact, and they said he had free rein, carte blanche authority from the carrier to try every issue in the lawsuit. He did so, and he was coverage blind because he did not involve himself in any of the coverage issues. And they held in that case that the insured was not entitled to recover his attorney's fees that he paid independent counsel because he got a fair shake from the defense lawyer. But that doesn't solve the problem. The problem is when the lawyer has to look from the beginning of the case and say, is there a potential conflict? Now, we disagree on the effect of McGee, or whether McGee was right, because I think the issue of coverage concerning whether he was a resident of the household has nothing to do with his liability for negligence as a driver, so that the steerage, if you will, can only relate to negligence, and the defense lawyer is trying to show that he was not negligent. However, by using this approach that Bob and Dick have used, you can see where you can find a conflict very easily, even though it's not relevant to the issue to be tried in the underlying action. Dick, you have any thoughts on that?
Yeah, I agree with what Bob said about McGee. I have trouble with McGee. I don't think McGee solved the insurance industry's problem with Cumis. I don't think Senate Bill 241 solves it. And let me try briefly to put my view in some perspective. In the first place, I don't think Cumis is novel or extraordinary at all. I think it is an extension, and not a very large extension, of conventional conflict of law principles to which all of us, members of the bar, are subject. And you'll notice Bob, in discussing it, used words like opportunities and potential, and you used those words. The Cumis case, to my reading, does not say that you are all a pack of scoundrels. It only says that where a lawyer has an opportunity to resolve a matter of interest to his or her client and resolves it against the interest of that client because of that lawyer's allegiance to some other client or party paying it, in this case the insurer, we shall declare that to be a conflict of interest of such dimension that unless waived, the client has the opportunity to engage its own counsel. Now, so I say Cumis just applied conventional conflict of interest principles to the insurance industry. Now, the Cumis case, I think, tried to do a good job, Bob. I think it tried to do it on a case-by-case basis, and it might not have spelled it out as well as it will later be spelled out. These cases badly need refinement. Cumis hasn't been refined. McGee certainly hasn't been. As I read Cumis, it says, where there is a reservation of rights and the carrier is represented by its retained counsel, and that retained counsel can control the coverage issue, that is a disqualifying conflict unless the insured waives it. Why? The concern, of course, in Cumis is not a prediction. You know, our conflict of interest laws don't predict that lawyers act unethically. They only constrain them from doing that by trying to remove those opportunities. That's all they do. That's all I think Cumis does. Cumis says where that opportunity exists, we are concerned that the lawyer may act unethically and may call a disputed shot. He will be making decisions one way or the other that affect coverage. He may make that shot for the carrier because he has a historic relationship with him, and the insured is a stranger. Now, that upset people, and I think I understand why it upset people. McGee now overreacts. I think what McGee tried to say, and I agree with you, Bob, you did not say it well. What McGee tried to say is that where there is a reservation of rights and the retained counsel is representing the carrier, if there is an objective fact that determines the coverage, a fact beyond which or over which retained counsel had no control, there may not be a conflict. But unfortunately, McGee, perhaps in its zeal to correct what it regarded as the excess in Cumis, picked the wrong case. because when you and I talked about that case, and we find that the coverage issue in McGee is whether, remember, the other passenger was boyfriend, apparently resident boyfriend, if you remember that. And if the other passenger was a resident of the insured's household, there would be a coverage exclusion. Well, just think about that a little bit. And isn't that a fact-intensive determination, whether the boyfriend is a resident of the woman driver such as to be within the family exclusion or resident exclusion? Ed is absolutely correct that it would be irrelevant, but that doesn't mean it's not going to get litigated and perhaps controlled by the retained counsel. So that's where McGee is. My problem with the punitive damages portion of 241 is they took McGee a step further. McGee tried to do a little bit more, perhaps, than it should have. 241 does even more. 241, as I read it, deems that the mere allegation of punitive damages will not give rise to a conflict. I have difficulty with that, Ed. I think that those cases have to be decided on a case-by-case basis, because consistent with conventional conflict of interest principles, consistent with the non-controversial parts of CUMIS, there will be situations where punitives are alleged, where the carrier either reserves its rights or does something not conceptually different, but simply taking the position that it is not covered, and it now has a lawyer, the insured now has a lawyer, who knows that the person paying it will not pay it for the punitive damage defense. It doesn't perhaps care whether the insured goes down in liability on a punitive damage theory because it's not covered. And would many lawyers do that? I think not. But the principles of conflict of interest don't predict whether he will or will not abuse that situation. They simply try to foreclose the situation. And 241 does it the other way. I think there will be times when an allegation of punitive damages, when inquired into in the context of the lawsuit, will reveal a conflict of interest that CUMIS would attend to. I think there are times when it would probably not. But again, I think it's on a case-by-case basis, and I think 241 painted really with too broad a brush.
You got that? You can see.
What do you say? What do you say?
That's only our first point on the agenda. I think we've handled the conflict situation very well. Bob, who has the duty, Bob Shively, who has the duty to notify the insured of the conflict? I didn't see anything in the Act that addressed that subject.
No, it really doesn't. But first of all, I want to say that we weren't in complete agreement. We had about 7 hours of conversation on this one point of punitive, but it just, in fact, it illustrates that this act is not going to change things for us. We're going to litigate. I disagree with him, and if he says he's the CUMIS attorney and there's the potential for your appointed counsel to turn this case against the insured, I said, no, there isn't. We're going to have litigation.
In a word, Bob, my point is that the big point is conflict.
Yeah.
All the other points flow from it. The other points are, they all
Exactly.
flow. The big question
Exactly.
is conflict.
That's the big one, and they don't define it.
Yeah, and cases tried to define it imperfectly. 241 tries to define it, defines it imperfectly.
Even with the punitive damage issue, the Act says there is no conflict. But Bob and I were talking that in most cases, there will be a conflict because you're going to reserve your rights, since those punitive damages are based upon
Willful,
acts of
intentional.
willful, correct?
Yeah, willful, intentional, and that's the allegations in the complaint. And unless you want to put yourself on the hook for the compensatory damages, you're going to have to reserve your rights on the compensatory that it doesn't meet the definition of an occurrence or accident or an exclusion for intentional willful acts. And so the fact that the punitive are in there, you're still going to have a reservation, which gives an independent counsel right. So,
Okay.
But getting back to the question you asked,
The question,
I
Bob,
opened the whole thing up and
yes.
you kept on some other tangent.
Who notifies the insured of the conflict?
That was the question. You're right. As I read 241, it doesn't say who has the duty to advise the insured. CUMIS decision, as I recall, does not say. A Bogart case that followed the Cumas decision does specifically say that the insurer had an obligation to notify the insured of the conflict. Regardless, I think if there's an obligation on the insurer to do so, I think they can do it through appointed counsel. What difference does it make who does it, as long as the insured is advised? I think retained counsel should advise the insured, because the attorney has the conflict, trying to represent two masters. The retained counsel has the opportunity to sell his expertise or the firm's expertise to that insured and get an informed consent. And there must be, the 241 said, the insured can waive the right to independent counsel even though there is a conflict. And then it gives the language that the insured has to sign. But it has to be an informed consent. Just merely getting the insured's signature on the language of the act, the insured could later attack, like they do in medical malpractice, where, yeah, I consented to the operation, but I wasn't really informed, and you didn't get my informed consent for this surgery. You didn't tell me all of the possible dangers. For these three reasons, I think it should be the appointed counsel.
Can I interject here for a moment? Don't you, in the not the usual case, but say the offbeat type case where you got really difficult facts to contend with as to whether or not there is any coverage for liability or defense under your policy, if you don't do it in-house, do you send it out to an attorney for a coverage opinion?
Outhouse attorney?
Outhouse attorney, right. And get that
otherwise known as retained counsel.
A binding opinion.
Not a binding opinion from outside counsel? No way. We can disagree with outside counsel on coverage interpretations. Yes, we do get outside opinions from counsel.
The only thing is, what I want to disagree with you just a little there, because if you have your coverage opinion from outside counsel, and then, depending on what the outside counsel says as to the coverage, you go to retained counsel, not that counsel. Then you go to retained counsel, and you apprise him of the lawsuit and so forth, and look over the facts and everything else. You don't necessarily send a letter to the insured at that time saying that there is a conflict, because I believe that the Cumas did say that it is the ethical obligation of the attorney, the retained attorney, to determine if he has a conflict, and if he does, he has to go to the insured and explain it to the insured and advise the insured he has a right to independent counsel to be paid for by you.
The way I advise the claim people in Royal to do is that to send a reservation of rights letter to the insured. Say it's been your defense has been sent to such and such a law firm for the defense. They will be in contact with you, saying nothing about the conflict. In the letter to the retained counsel, there should be some kind of a notation to the effect that I think you may have a conflict here. Here's a copy of the reservation of rights letter. I assume, if you agree you have a conflict, I assume you will fulfill your Cumas obligation. Period. I think ordinary defense counsel knows what Cumas obligation is.
Bob, what percentage of cases where there is a reservation end up with independent counsel? Do most of them end up with retained counsel?
Where our first notice of lawsuit is not through the insured's attorney, but it comes through without the insured's attorney being involved, independent counsel. A great percentage of the cases, the retained counsel retains the case.
Okay.
Is able to convince the insured that they are qualified, that they are not going to get into the coverage matter one way or the other. They're upstanding, honest, I swear.
Okay. Well, moving right along, we've got a few other items to cover here. And we'll have to treat them quickly because we got a late start. But the next area is that of the qualifications of independent counsel. The Act specifically provides that the carrier can require minimum qualifications which include, but are not limited to, 5 years of tort litigation, substantial experience in the subject at issue, and errors and omissions coverage. I keep saying this, Dick, but what the hell does substantial experience in the subject at issue mean?
Well, and as we say, it's not a defined term. I guess no one knows, but it'll be litigated someday, probably. But it's not it's going to be anything. I think the carrier clearly has the right to inquire into the credentials. They can cross-examine. They can make any reasonable investigation. They're clearly entitled to do that. And if it turns out that this man or woman, independent counsel, has considerable experience, substantial experience, as most of us use that word in our day-to-day practice, then that inquiry probably should end. I think it's legitimate for them to cover themselves by insisting on errors and omissions coverage. I don't think any of the qualification inquiry is or should be at all offensive to independent counsel.
Okay. Let me try and get Scheibele in trouble here. Bob, what about, what would your position be where, say, a tender of defense comes in of an antitrust lawsuit, and they say, we would like Dick Lucas to handle this case. He charges $500 an hour, but he's experienced in antitrust litigation. And you look over your approved counsel list and you see, geez, there's McFetridge. He doesn't even know what antitrust means. And no one else down there looks qualified. What are you going to do? Are you going to pay him his fee, or are you going to pay him a lower fee, or what?
Well, first of all,
500 would be generous, Bob.
but would it be fair, Dick?
He'd have to take it.
Good faith and fair dealing goes both ways. No, first of all, I would look at our normally retained counsel, we call it the approved list of defense counsel, to see if there's any expertise in those firms that can handle the type of case we're involved with. If it's a first notice lawsuit, I'd like to know a little more about the case to see how complicated it is. If I can't find anyone in our retained counsel defense firms that I believe could, has the expertise there, I would not want to stand the chance of trying to keep it in a retained firm. And therefore, I would not object to Mr. Lucas defending that case. I would attempt to negotiate his fee, and he's a real nice guy, I've learned in the last several weeks. I think we may be able to do some business on it.
$450.
That's only a second demand. He's got a long way to go.
I saw Lynch before, lowballish.
I took antitrust as an elective in law school. If you want, $350.
How many years ago?
That brings us to the fee.
$350. What's the difference?
But let me.
You get what you pay for.
Let me add just one thing. I would not, if I couldn't find that kind of expertise in normally defense counsel, I would negotiate and I would let Mr. Lucas handle the claim. For a couple of reasons. I think the insured may get a better defense than he would be from a neophyte in that field of the law in a retained firm. I wouldn't want to pay for a new counsel going to school in that field of the law they're not used to. I don't want to pay for that education, which can get very expensive. And the insurer is going to get a much better defense from the kind of expertise that Mr. Lucas has in that case. Maybe it'll go quicker. Maybe the final cost will be much less than sending it to a retained counsel.
He's been listening to Lucas too much lately.
Did I say that the way
Actually,
you told me to say?
Perfect. Really perfect. Actually, Dryden would do it for 125, but he's a very slow learner.
Take a lot of depositions, too. With those rates, it reminds me of the story Abraham Lincoln told about the lawyer that lost a case, and then he went back to the court, I think, to find this Coomis situation, and he moves for a new trial on, the judge says, on what grounds? And he says, newly discovered evidence. Judge says, what newly discovered evidence? He said, well, my client found $1,000 I didn't know he had. 250.
Okay, we're on fees, and the act...
Wait a minute. Anyone out there? 250.
Do I hear 150? The Act provides that the carrier can pay the rates actually paid to attorneys in defense of similar actions in the community where the claim arose or is being defended. Now, I think this may be the subject of some problems, but obviously in the standard case it should not present a major problem for the carrier to simply say, well, this is an assault and battery case with allegations of intentional acts, punitive damages. Dryden does a lot of that assault and battery work, and he charges $125 an hour. And so we will pay you, Mr. Independent Counsel, $125 an hour. I don't see a major problem there, but the Act does have a provision for arbitration if there is any problem. Now, we're back to the situation of the similar case, so that if you have the complex case, one where you don't have an attorney that you have paid in a similar action, you're going to have to negotiate with Dick Lucas, because he does have the expertise in that particular area. What about this arbitration provision, Bob Dryden? Can the carrier say, well, look, you want $250 an hour, we only pay $100 an hour for this, we'll pay you that, and you can arbitrate it later if you think you're worth more? Is that the way you see it working?
Well, the Act itself states that attorneys, any dispute concerning attorneys' fees not resolved by these methods shall be resolved by final and binding arbitration by a single neutral arbitrator selected by the parties to the dispute. Now, there are going to be areas here. We're not talking about the case where a business tort, say securities litigation, banking, antitrust, things of that nature, where a fellow like Dick Lucas, with all the experience that he has in that area and the good work that he does with co-counsel, retained counsel, and the industry, you're not going to have too much trouble with a Dick Lucas. But you will have in the offbeat case where you have a neophyte lawyer, doesn't have much experience. He's not the lawyer that has the 5 years experience, or if it's 5 years, it's not substantial experience in the area which is the subject of dispute. Those are the lawyers you have an awful lot of problems with, and I've heard horror stories about that. These fellows are generally out of control. Joe Cotchett, I think it was in May, gave a talk here on closing arguments before the association as a plaintiff lawyer. And I remember Joe said that trying these antitrust cases he had down in the Raiders case and so forth down in L.A. and all, he said you should see some of these lawyers for the industry or something, or for the defendants there, getting up there, and they take umpteen thousand depositions. They have 5, 6, 7 people on a deposition like nuns, you know. They can't go to the bathroom without 2 or 3 of them there, and they charge for that. And he says, but you know, it gets right down to it with the lack of experience that these fellows have in actual jury trials, which the insured wants, a trial lawyer. He said, these guys, I see them look in the eyes of the 24 people in the box, and they have involuntary bowel movements. And that can't happen. If you have a situation where the fees are too large, say Bob Shively would say, we don't have substantial experience in this area of antitrust or securities litigation, but that fee, $500 an hour, is pretty steep. We're not paying that. We, by the Act and by the law, state that we pay reasonable fees. We don't think it's reasonable. Now, here's what we'll do. We'll either go to arbitration now, or we'll put the balance of what you want and what we'll pay into, say, an interest-bearing account, trust fund, and we'll take care of that in arbitration at the end of the case. You want to do it that way, or you want to go to arbitration now? I don't see any problem with that. I think we're agreed. Well, the problem I see, and I don't know if anybody has the answer to it, is if you have the garden variety case where you have an impecunious insured, and an insured goes out and hires somebody that doesn't have much experience, and he charges like Dick Lucas does, and he says, I'm not going to accept that fee. If I don't get my fee that I want, I'm not going to take this case. then you are running a risk then of interfering with the defense of of the insurer, I think. At least that's something that the Act hasn't addressed, nor has the law yet. I know that you can go into arbitration, and the arbitration, of course, is set by the Business and Professions Code, Section 6200, et sec of the Code, and the statute makes the award of the arbitrator in that area fees binding. So, of course, if the local bar associations follow the procedures of the state bar in that area of fees, then you will arbitrate by a single arbitrator selected by the parties before a local bar association.
Okay, thanks, Bob. How about reporting? Bob Shibley, the Act says that the counsel shall disclose all information not privileged or relevant to the coverage dispute. Are you going to insist on independent counsel reporting to you, Bob?
Yeah, I want enough facts so that I know what the question of liability and the worth of the case is. I'm not going to press for the coverage issues. That's privileged. I can't get it. The Act says so, and I never thought I was entitled to that anyway. But tell me how I enforce that. I know what the Act says, but it doesn't say how I get it. If I want it and the attorney refuses to give it to me, how do I get it, Ed?
You mean, how do you get your reports?
Yeah,
from
how do I get my report?
They've been asking me to do that for years. But I'll get it as soon as I can.
See, you ask for legal advice, and that's what you get.
No, there is a provision in the Act for resolving disputes where you can't get information. Bob, did you look into that?
Yeah, the Act does state that with respect to timely information and reports in the preparation of the case and so forth, which is not privileged material. The privileged material would be documents, memoranda, and so forth between the Counsel counsel and the insured as to coverage. That is privileged, but the rest of it, you can file a motion in the Law and Motion Court, and you have standing as retained counsel to file the motion because you have statutory standing given by 241. File a motion, and all the privileged material and all the documents Counsel does not want to give up will go to the Law and Motion judge to determine if there is a privilege. Then it will go over to the retained counsel for delivery to the insurance carrier. And that's all privileged material. It doesn't go to any other party to the action, plaintiff or co-defendants.
Oh,
Good. I had to hire a Dryden or McPetridge, and it's still costing me money.
$2.50 an hour.
Okay, the final provision in the bill relating to independent and retained counsel pertains to the cooperation between them and the cooperation of the insured with the carrier. It says that they must cooperate and must work together. Now, Dick, is that going to present a problem for you if you're independent counsel to suddenly be faced with a retained counsel that you have to cooperate with?
Well,
Given the fact that you think he may try to, tailor the evidence in favor of the carrier and against coverage, is that going to affect how you handle the case with him?
I think from the point of view of the independent counsel would take the position that he or she controls the litigation. And no one wants anyone tugging at their sleeve, next to them suggesting questions, writing out questions for them at counsel table. None of us welcome that. I have not seen that happen. I have not had a carrier. I have had no experience with carriers appointing co-counsel. Supervising insurance counsel on coverage matters and other matters, monitoring counsels for fees perhaps and other matters, yes. Co-counsel, no. I think it would be a somewhat unusual case for a carrier to willingly agree to now pay two sets of lawyers. So I don't know how common or uncommon that is, but there's one area where there cannot be any cooperation. That is, to the extent the independent counsel learns of privileged information that, short of perpetrating a fraud, would affect coverage, he is, I understand, duty-bound not to communicate that to the carrier. And however much he wants to cooperate with that co-counsel, retained counsel, he can't tell him or her about that confidential information, can he?
I think that's right. I think our consensus is that the retained counsel is not supposed to be interested in coverage anyway, so he doesn't care about that information.
Yeah, there are two ways we can retain counsel. One, retain counsel to act as co-counsel for the defense of the case. The other, we can retain a counsel to represent the carrier.
I think that's what you're seeing more and more. At least that's what we've seen. Yeah. The carriers are accepting Kumis counsel once they have worked out the fees. Then they hire coverage counsel to represent the carrier up front, to monitor the case, and if necessary to bring a declaratory relief action concerning insurance coverage. And he's the conduit between the insured, independent counsel, and the carrier. Well, we are now at the point, and we just have a few more minutes since we started late. We'd like to go through where are we and where are we possibly going with this act. I think we've covered the basic provisions of the act. One of the points that we have considered is, can the carrier now take control of the case? Because here you have the statute says the independent counsel must cooperate, must give him all the information he needs. Can the carrier limit the work of counsel? Can he demand reports at all stages of the proceedings? Bob Dryden.
Yeah, I don't see how, in the present state of the law, either pre-241, under Kumis, or even before that an insurance carrier where there is a conflict and there's a reservation of rights can assume control of the litigation over the requests and desires of the insured and Kumis counsel. The only thing I know that some of the clients that I've had where there is they look at the potential for a verdict and in what various areas of the case, the dangers of the case. If they find that it looks like it's a defensible case, that if damages are awarded, they are going to be within the compensatory range and they're going to be small, they will withdraw the reservation of rights. I believe that a lot of carriers have done that to avoid all these problems. Because if you don't do that and you assume control, over Kumis counsel, and you don't let him do what he wants to do in the preparation of the case or in the trial of the case, you are into an area where you are controlling the contract between Kumis counsel and the insured. By taking control there, you can be sued, the insurance carrier, and the attorney can be sued for emotional distress of the insured and others in the event the case goes sour or goes bad. Read the Purdy case. That Purdy case holds that the insurance carrier was liable for exerting control there over the wishes of the insured, although retained counsel was not liable because there was an independent counsel involved. But there are cases like the Betts versus Allstate case and so forth, which gives obligations on the part of both counsel and the carrier, which is a fiduciary, not to interfere with the retention of control of the insured in the preparation of a case where there is a reservation of rights. I don't see where there is any basis to take it over. I do say this, though. If in fact the case is going sour because of the inability or the lack of trial experience of Kumis counsel, and you point that out to the insurance carrier, you, as retained counsel and the insurance carrier, can write and lay the groundwork for a reverse bad faith case against the insured in case something goes bad and you have to pay the judgment. That's that California casualty case and the Fleming versus Safeco. You read those cases and you find that all is not lost if you're not getting the cooperation of the insured and Kumis counsel under the policy.
Okay, one area that has to be watched closely is where the carrier does defend, and he reserves the rights not only as to coverage, but to retrieve the costs and attorney's fees back from the insured in the event that there's a determination of no coverage and no duty to defend. Mike Brady discussed this morning, so we won't go into that in detail, but this insurance company of the West case, which I do not believe is final, discusses that and says that in absence of an agreement, there are several cases on this subject, as you know, but in absence of an agreement with the insured, you can't defend and then come back in and recoup your attorney's fees, even though you have established that there's no duty to defend. This is covered also in the Lesher case, but those are cases that will have to be watched. Okay, now that we have this act, where is the beef? Where's the bad faith now? Are the carriers off the hook? Well, Dick, what about where the carrier does try to control you or does not pay your standard fee, where your client may be in trouble since he can't afford to pay you, or it's going to put him in financial straits? You've represented this client. Let's say it's a bank. You've represented him for 20 years. They've always paid $500 an hour.
Not 500.
And we're trying to make you look good. Is that interfering with your contractual relationships with your client?
Yeah, I think as Bob said, that is a very, very sensitive area, and if the carrier is too aggressive, either on the negotiations of the fees, the terms under which the fees are to be paid, the timeliness of the arbitration over the fees, he runs the risk that he will breach his covenant of good faith and fair dealing with his insured, who, after all, wants the matter to go along smoothly, wants his lawyer, his independent counsel, untroubled by these side disputes. It's a sensitive area, and 241 doesn't much help out, I don't think.
Well, to the extent that 241 does attempt to permit regulation of attorneys' fees, is it constitutional?
Well, I think maybe the best answer that can be given now about that is I think there's a serious constitutional question with 241. I think it might, and that's one of the questions, I think it might even be broader, Ed. As I understand the constitutional question about 241, it goes something like this. There is well-established case law in California and elsewhere that decided that the judiciary is the exclusive arbiter and regulator of the bar. The lead case on that is the Husted v. Workers' Comp Approvals Board case, a 1981 Supreme Court case. So the judiciary and only the judiciary can regulate the conduct of lawyers. Now, the legislature can enact laws that reasonably regulate lawyers. Well, the question then is whether 241 usurps the judiciary's exclusive role as the arbiter and regulator of lawyers' conduct. So there will be a question, if 241 is construed too aggressively, it may well be said to have unconstitutionally intruded on the judiciary's right to control lawyers. Here the legislature is controlling lawyers. So there's a question.
So you foresee the possibility of the constitutionality of the act being attacked by some Counsel counsel down in L.A. Never happened. The final question is when is this act effective? It's silent as to when it is effective, and therefore under the Constitution, Article 12, Section 8C1, it is effective 91 days after the last session of the legislature. That means it's effective in January of 1989, so that you cannot apply it now. 88.
That's right.
And I think Archie Robinson made a good observation in the CDC Reporter by saying that to the extent that the Senate Bill 241 is reflective of existing law, you can probably have it operative now. But that's another area to be litigated. But we don't have much time between now and January 1, so what the hell, huh?
Yeah.
Why raise Frankenstein?
I have one more question, and that is, how about the cases that are in existence on January 1st, and you have either negotiated or not negotiated a price with the Counsel counsel, an hourly rate with the Counsel, and now it becomes January 1st, and you say, hey, according to this act, I don't have to pay you more than we pay our standard retained I was going to say normal retained counsel, but I don't like that term, normal. Retained counsel, our retained counsel, we don't have to pay any more. Now what happens there?
That's one of the aforementioned sensitive areas, Bob.
Is that an interference with the contract?
Well, we know what's going to happen because they're going to write the letter saying, we've just read it, SB 241. It's effective January 1st. We're now going to pay you $125 or $100 an hour.
I would caution people not to be easy on that. You may be interfering with a contract, and that in that fair faith and fair dealing, people are out there watching us for.
So you would try to negotiate it. Listen, we're out of time. We thank you for your attention, and we'll be happy to answer any questions.
Good job, Ed. Very nice. You too. Very nice.
The President's reception will take place at 5:30 for all of you who are attending.
One caller comes up to you and says, please.
Hey, Neil, how you doing?
If one?
You say, please reduce your fee. Yeah, I've been on please.